Okay. I like to mention item number 7, Lordship, with the consent of the petitioner, Lordship.
Yes.
Are there is in bereavement, Lordship? The matter is taken after petition. Item number 7.
Item 7, request is made on behalf of the article. See that she's in bereavement, where is the refer the matter after vacation.
All right.
Now, please stop the video.
Wait, please. I like to mention listing.
Unlisted. No, not on. Listed tomorrow, day after.
May please, your may please, Lordship, listing for the day after tomorrow, motion matter.
Motion.
If the rest of mention for listing of withdrawal for withdrawal matter. I have a prayer for listing tomorrow.
Motion.
Motion. Similar prayer for tomorrow. Motion. Similar prayer for tomorrow. Lordship, I am payable listing tomorrow for motion.
For motion.
Lordship, I bid for a listing of one matter on 26.
Motion, admission,
Motion.
motion matters.
Maybe listen, Lordship. Item number 8, my kindly adjourn for this day.
Item 8, request of the petitioners and refer.
Obligation.
Lordship, I recommend a listing of a rate petition for motion, Lordship. Friday, Lordship.
Friday.
Well, item number 9, we kindly taken up.
Item 9,
Yes, ma'am.
request of council to stand refer.
May it please your Lordship, Lordship, I am appearing for listing of a matter for motion with petition on Friday.
Friday.
Motion matter of Friday, Lordship. How much is of pens?
May it please, your Lordship, I beg to mention item number 51. I am praying for an upgrade.
51.
51 of the supply list. Immediately after motion, if it can be taken.
Why you want an update?
Your Lordship, it was heard earlier many occasions. So today was the date fixed for disposal.
No, updation is not required. Call it up. During the course of the day.
Obliged.
Please please your Lordship. The concern of the other side, I beg to mention item number 1. Lordship, we need some instruction from the person. Kindly answer.
Item 1 will come right now. Wait.
That is about it. I beg to mention item 30, my lord. Item 30, related civil bench to matter, my lord. Can it be taken on tomorrow, my lord?
Item 30.
30, my lord.
Sorry. Item 30. Right, we will check up and if it is there, it will be listed tomorrow before appropriate.
I had
The registry will take steps to list it for appropriate bench. That is all we can say. We can't say list it tomorrow before bench.
Like because next 2 days we have got
Bench 2 matter.
bench to but what principal by college. Paper bench tomorrow, Lordship can say. Is it possible to say?
No,
paper
not
bench
possible because I do not have the power to
Yes,
transfer matter from one bench to other.
Paper
I can only
bench,
say
Lordship
the
can say. Lordship can say.
registry will examine and endeavor to list the matter tomorrow.
That's what I say. Tomorrow only. Let the paper bench. That's true.
Item 30 submitted that matter pertains to matter. Take steps for a bench if possible. So we will take.
Not with the Lordship. For listing of petition relates to pension. Lordship. Can it be on Friday, Lordship?
Admission, motion.
Motion.
Yes.
Obliged. Similar prayer for Friday, Lordship.
Motion matter.
Motion.
How many?
2. It is your Lordship. Lordship, I beg to mention listing of an writ petition for Friday, Lordship.
Motion or admission?
Motion matter, Lordship.
How many?
Lordship 1.
Friday.
Obliged, Lordship.
May I please Lordship. Lordship, kindly list the matter for admission.
Which matter?
WBC.
Huh?
WBC.
Where is that?
Matter related to.
Where is your mention memo? A reply file?
Yes, Lordship.
Let it come in August,
Lordship, kindly July.
July. 29 July.
Matter for listing for motion, my lord, on Friday.
Right.
Obliged. Maybe the lordship. My lord, sorry.
You're seeking an adjournment.
Yes, my lord.
Right.
My problem is that
In the adjournments, we circulated matters then but they listed in after 3 weeks. Yes,
after 2 months, my lord. After 2 months.
2 months.
My lord.
Why?
This abroad, my lord, for treatment, my lord.
After 8 weeks, as it is submitted that the petitioner has as an oral submission is made by the council that the petitioner is on treatment outside the state of Assam.
India, my lord. If the
Mr. B. Sharma for the respondent.
Every election, item 2 and 3 are similar, my lord. I had already approached the reviewing authority after the appellate judgment has been passed, my lord. In item 3, the hearing has already taken place, but judgment has not been pronounced. In item 2, hearing is to take place within a week.
It is submitted by the council to the petitioner against the order passed by the first appellate authority. The petitioner has prepared a review under the regulations
64D.
762D.
D of the technical instructions that will lead to the term review. So it is submitted that the matters are in the stage of hearing. Therefore, submission the matter good. And after 4 weeks,
My lord,
after 3 weeks. Mr. Reyes, Doctor for Revenue, our board state.
Of that.
highly obliged.
Order page number 49, my lord. Order page number 49, my lord.
49.
49, my lord. Then paragraph number 6. Yes, please.
Our council for parties, we should look at certain steps on spot by speakers.
Obliged.
Principal, last proposal instructions were sought from the other side.
But Mr. Gauhati is a man. Kindly talk about this matter. Kindly.
Matter is fixed only for instructions, whether instructions are received or not. That much you should have been able to submit before the court.
We have received the instruction.
Tell us what is the instruction. Timing.
Sir, in this case, my lord, we have filed one,
Additional affidavit.
yes, my lord, saying that, my lord, we are appointed by the local villagers because in the Bongaigaon district there is no Gauhati.
What is your prayer?
My prayer is, my lord, to consider our grievances in respect of, my lord, weight rest may be given at the time of regular recruitment.
Is there any provision under the
No,
law?
no, no such provision.
Then?
No, sir, they are, my lord, rendering their services more than 15 years, my lord. My lord, the honorary service they are giving, my lord. 109, my lord, in my representation, my lord. Only our prayer is that, my lord, sir, we, the members of the association under highly experienced should be get privilege over the new entrants as Gabura if required by holding the selection and verification of the documents. Further,
What is the process of, what is the status of selection now?
Now, the selection, that due advertisement, it has been selected.
selected.
No, new
Advertisement was not published,
Published.
Lordship.
Still
My lord,
there.
after the advertisement, the selection process has been taken. My lord, in the, my lord, my learned friend said, my lord, regarding the weightage cannot be given as because they are appointed by the villagers, not by the district administration. So, my lord, the weightage cannot be given.
Now,
There are some other matters, Lordship, already been rejected. That pair has been already been rejected by the department.
they have applied for the pursuant to the selection.
No, they did not
No.
apply that.
Earlier applied, my lord, but as there was some restriction regarding the upper age and the matriculation, that's why
They are
that was
approaching
challenged.
before this honorable court, my lord,
Yes,
they're challenging that advertisement.
But no new advertisement published, my lord. Nobody is
Only
appointed.
because
no
of
advertisement.
litigation, my lord, the retest cannot be
No,
done.
but if you have not applied to the
No
advertisement,
advertisement, not published, my lord.
not published.
Not published.
So Lordship can give a direction to the deputy commissioner to publish, my lord, the selection.
They will appear. We are intending to appear in the selection process, my lord. That is why our.
No, but on the ground of villagers appointing you,
Yes, my lord.
where do the villagers get the authority to appoint you?
No, my lord, pursuant to one notification, there was a notification, page 99, my lord. Deputy Commissioner has to select such a person, my lord. Page 19, and I have annexed here. Appointment of honorary Gaura at the relevant period in the year 2000, my lord. I am directed to say that the government of Assam has decided to appoint one honorary Gaura in each of the revenue village of the state, excluding the 6 scheduled area. For this purpose, a revenue village would mean a fully custodially surveyed and inhabited village, the land records of which are properly recorded in the village Jawanbandi and would not include any non-cadastral village, uninhabited village, and forest village. This appointment would be made by the Deputy Commissioner on the basis of recommendation by the selection committee, consisting of a chairman as indicated below, and the additional Deputy Commissioner Revenue as a member, and a Deputy Commissioner of the concerned district in the convener of the committee. This appointment will be absolutely honorary, and the appointee shall not be entitled to any pay, allowances, honorarium, or any other financial part from the government. They would also not be entitled to any claim of any financial benefit in future also. In this way, one note.
Lordship, kindly see the second paragraph of this advertisement also. The appointment would be made by the deputy commissioner on the basis of recommendation made by the selection committee. Well, this is the selection committee. Deputy commissioner is the chairman on that time, Lordship, 2000. And the other ADC and the SDO, they are the members of the selection committee. After that advertisement, they have to apply, and accordingly, the selection committee has been selected the person after due interview. So, that they are given is that they are appointed by the villagers. There is nowhere mentioned in the letter, Lordship, regarding the person appointed by the villagers.
In this process, they are doing their duties. Earlier also.
What is the status of their employment now? Are they still holding charge?
No, they are not allowed to work in that district. In some of the cases, Lordship, already been disposed of, dismissed by the honorable court.
All right, you produce that order.
Lordship.
Take it up after vacation.
Lordship.
Matter be posted after vacation and submitted. Pending council review. That interactions. Court has passed orders. Dismissing secretary.
All right.
Released after vacation.
Can you fix the date?
Second of July.
Lord.
Mr. Das for petitioner. This will be ending for review. So we have to state. I think the provo timing for a Yes.
termination of the petition during the period of probation. It will be on the ground that I have submitted the false information as regards to my residence. I have referred an appeal to the record, but that is pending as on date.
Appeal.
Appeal has been pending before the authority, provided by the rule minor. Under
So you withdraw it and refile it after the appeal, in case the appeal
well, as
is
of
dismissed.
today, the appeal has not been disposed of. I
Okay.
have filed the appeal on my.
Then we'll direct the appellate authority to.
Yes, madam, to dispose of that.
Yes, Mr. Heavy.
Madam,
Since the appeal is pending,
that I have to obtain the instructions, madam,
we'll
because
say that the order be passed, and if already passed, then copy will be served. But Mr. Sharma, that is easy. Was employed as a constable PSA pursuant to the selection process undertaken during the verification of PRC/domicile certificate. It was found to be correct. Subsequent petition was so called by the authority, stating that the character and antecedent had not been done by the office of the additional district magistrate. Petitioner submitted a reply, however, without considering the runs of petitioner. 8/11/25.
25. 25.
Petitioner was terminated, relying on the report given by the additional district magistrate. Yeah. So, against say dismissal order, it is filed an appeal
On
before
before the mother.
the appellate authority. Same has not been disposed of as date. Petitioner is therefore approached the scope. Considering the submissions made by the petitioner that dismissal order petitioner pending. Past considered petitioner is closed, directing often as also the appellate authority before which the appeal is stated pending to expeditiously dispose of the appeal by speaking of. So, needless to say, any order that is passed, copies thereof shall be served on the petition. So, in the event any order has been passed in the appeal preferred by the petitioner during the pendency of the court, pendency of the writ petition, copies thereof shall be served on the if the appeal is disposed of within a period of 90 days from the date of receipt of a certificate copy of the court.
Within 2 months, madam.
60 days. Disposed.
Alia.
All right.
Yes. April.
That's it. The direct counsel is on next, that's it. He is in court one.
Maybe in any court, but you are there. What is the instructions of court?
Proceeding the last purpose on the petitioner, the petitioner is appear or not in the court. There is a committee formed by the division bench for scrutinizing their document. But my case is, lordship, there is a division bench order, lordship, recently passed. The court allow all the grade 4 employee and reinstated them, lordship.
Where is that
And
order?
that order is, and that's lordship page number 69. And the similarly situated person, lordship. Now, all the cases are allowed by the division bench. All terminated candidates are reinstated, 140 number of candidates.
And where is the question of appearing before a committee?
Yes, lordship, in my order, lordship, page number 31. Earlier, I filed an repetition, lordship, challenging the termination, lordship. Where the court directed, lordship, that the relevant portion is page number 40. there are 10. The writ petition order, Lordship, observing the division bench order, this
This
order
writ petition was filed by whom?
filed by the present petitioner and some 3 others.
What was the direction here?
Page number 10, Lordship, the 11 portion. Page number 40, paragraph 10.
Now, why have you filed this petition again?
Lordship, they have not considered anything, Lordship, till that no decision has been taken. And one more thing, Lordship, after my termination, Lordship, the CM Vigilance Authority, Lordship, all they kept my all documents, Lordship. I have annexed this.
No, you have approached this court earlier,
Yes,
and in that, the writ petition, the order passed is on 22/11/21.
yes.
The penultimate direction is paragraph 10.
Yes,
Where it says that the matters which stand covered by the division bench, you are allowed liberty to appear before the committee constituted by the division bench.
yes. Yes, thereafter, Lordship, I appear, Lordship, but due to my original documents is kept by the CM Vigilance, Lordship, my appearance is not considered, Lordship. But after that, Lordship, recently 2026, the similar category of person the division bench allowed, Lordship, all the cases.
Where is that?
That order I have, and the Lordship last page number
And what is the division bench order referred to? In the page number
69. 69.
page number 41, what is the order referred to?
So this one is, Lordship, for earlier litigation, Lordship. The similar category of person, second time again prepare an appeal. Lordship. These are the appeal. This appeal is filed for the earlier litigation, Lordship, where the division was directed to consider the petitioner's claim and form this committee, Lordship, to verify the documents, whether their documents is genuine or.
You have not been able to explain. You have been given an order by the court.
Yes, my lord.
That order has not been complied with, then your remedy lies elsewhere. Why have you filed the second writ petition?
No, Lordship, it's not a direction, Lordship.
Paragraph,
Yes, paragraph 10, Lordship. In view the
Paragraph
fact
10.
that the petitioners therein similarly placed as the appellant in the dispose of writ appeal mentioned above, and as per the consent of the counsel for the party, that the case of the petitioner herein would be also be covered by the division bench judgment and order dated 9/11/2021. The petitioner herein are also given liberty to appear before the committee constituted by the division bench on 9/11/2021 in the office of the Director of Health and Assam, Hengrabari, Gauhati, to enable the petition committee to decide on the genuineness of the appointment order of the petitioners. That decision is still yet not taken. That's
so
why
if it is not taken, then your remedy lies elsewhere. Why have you come before the court
The-
after 5 years?
Lordship, the page number 38, the paragraph 9, the division bench observation is quoted. Lordship.
That's right. But if this order is not complied with, your remedy lies elsewhere. Why are you praying for a second writ?
Look, this is not a mandamus issue.
Then you go and appeal.
No.
You file the writ petition.
this
you dispose of the
basically,
matter.
I filed this petition basically relying the division bench order, Lordship, where the division
Whatever
bench
it may
allow.
be, if the order is passed, you are not happy with this order, go and appeal. Why will you come before the court?
Some subsequent developments there, Lordship.
What
The-
subsequent
The
development?
division bench allow all the writ petition.
Then you go and file an appeal before the division bench. Who's stopping you?
Lordship, against this order, I cannot go, Lordship.
You
Because
don't go,
in the
that
some-
is your call.
There's
Yes,
some other order also there, Lordship. Single
yes,
bench
madam,
order.
any instructions? What instructions have you got?
In this case, Lordship, D Upaminu is appearing, so let it come, Lordship may take it up after some time, Lordship.
Lordship, if you notice, Lordship, they file a reply.
No notice.
After some time, Lordship. Is in court number 1.
Doesn't matter which court. Your department,
I'll inform him,
is there a shortage of standing counsels? We will direct the chief secretary to appoint further standing counsels if required. Is this a ground that the counsel is not present in court, in X court, Y court? It's not a ground for
I will
seeking
inform the
time.
Lordship after some.
The matters are fixed in the presence of counsel. don't make these submissions after some time.
Applies.
Okay.
After present date, which time to instruct and
You had wrongly put your gender. By the earlier order dated 4/5/2026, Mr. B. Chaudhary, standing counsel, was permitted to obtain instruction that given the matter is called up, standing counsel is not available, department is not represented. Therefore, the court is constrained to issue notice, making it returnable after 4 weeks. Issue notice, returnable 4 weeks, steps. The respondents by speed post in 1 week. This thereafter.
It is the word. So here the prayer of the petitioner is to grant the minimum scale of pay in terms of Upendas.
Upendas is not here.
So that has been so I have to amend the prayer portion of the petition.
Counsel for the petitioner seeks liberty to file application seeking amendment. Prayer allowed, list after 4 weeks. Mr. M.S. B. Bora appears for etc.
One word, A. Goswami.
A. Goswami for respondent number 1.
Obligement.
Check, PPO has been issued.
PPO has been issued.
From government. ऐसा भी बोलेगी।
What is your claim in the writ petition?
Family pension.
Family-
As an unmarried daughter.
Unmarried
As an
daughter.
unmarried.
That has been PPO has been issued. FPPO.
And areas,
Have you received the FPPU? No.
No.
The copy is sent, PPO is sent to her in the treasury.
So we close the matter.
Yes.
Mr. F. Unlearned counsel for the petitioner, Mr. B. Chaudhary, the accountant general office, MD Chaudhary for
MD Bora.
MD Bora for
For 3 to their focus department.
3 to 10.
No, sir.
MS and Hazarika for respondent number. It is finance. Finance is not a party here,
Finance is
not a party.
2, my lord, 2. Principal Secretary Finance.
Respondent. Anyone else?
1.
And the DD report. 1. The petitioner claims to be the unmarried daughter of late Habibur Rahman Ahmed, was employed under the Prohibition Department. The father of the petitioner died in harness while serving as senior inspector auditor of the Corporate Society.
area they given on the
Earlier, the writ petition was filed whereby a direction to make incurring payment of 1 lakh petitioner's brother and respondent, and for release of the family use. 8. Furnishing certificate copy.
There's no mention about the areas, my lord.
Petitioner is paying her share of claim to the unmarried daughter. So, during the pendency of the writ petition, so the accountant general, its standing counsel has informed the court that the family pension payment order has been issued in favor of the daughter on 3/6/2026. Copy of the same is placed before the court. Counsel to the petitioner, however, submits that he is yet to complete his instructions on this regard of the petition. And from the perusal of the FPPU, it is not clear whether the arrears have been included. Enable the petitioner to take his instructions in this matter, month of July. It will come in July.
My lord, can I get a fixed date, man? Any date, man, as per convenience.
29th.
29.
29th.
I'm great. Meta pertains to appointment of incumbent worker. Initially, my lord, the petitioner was appointed as per advertisement of 2009. And my lord, in the year 2021, another advertisement was published to promote the helper.
Any instructions? No? Heard
notice station.
heard it counsel to the department. Mr. D. Bora, the state council appears for
All the 1 to 5.
5. The officers are paid. Respondent 1 to 5. However, extra copy will be coming. Okay. Steps on respondent 6 by speed post in 1 week.
Obliged.
May it please the lordship. I am appearing for the petitioner. The petitioner of the is conscious of the principle of alternative remedy. However, the present writ petition has been filed challenging the legality of the dismissal of order dated 16/7/2025.
Your forum would be the labor court.
Labor code.
My lord, ordinarily an industrial dispute relating to the termination may go to the labor court. However, the petitioner has approached this honorable court invoking the Article 226 because the challenge is to arbitrary exercise of the power of violation of principle of natural justice.
So can it not be examined by the labor court? What is it that
If your lordship on view that adjudication of disputed fact requires labor forum, then the petitioner may permitted to pursue the appropriate remedy with protection regarding limitation.
fine, whatever you approach the labor court?
The liberty.
Industrial dispute approach. Learned counsel to the party, the petitioner was serving under the Assam Cooperative It means limited at Gauhati. The petitioner was serving as what?
Serving as junior assistant of labor welfare office.
Serving as a junior assistant in the labor welfare office. He was dismissed from service by order dated
Order 29/11. Oh, the dismissal is on date 16/7/2025.
16/7/2025.
Connects are 12.
So, being agreed, he has approached the court challenging the dismissal order. Para Section 2, capital A of the Industrial Disputes Act 1947 provides that where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, terminates or workman, any dispute or differences between the workman or his employer connected with or arising out of such a discharge, dismissal, termination shall be deemed to be an industrial dispute, notwithstanding that no other workman or any union of the workmen, the party, to the dispute. Stop section 2, capital A, subsection 2 provides that any such workman specified in subsection 1 may make an application direct to the labor court or the tribunal for adjudication of the dispute referred to herein after expiry of 45 days from the date when he made the application to the conciliation officer. The view of these specific provisions, petitioner is permitted to withdraw the petition and pursue his remedy from specified under the Industrial Dispute Act 1947. Accordingly, the petition stands dismissed without any opinion on the matter.
Lordship, I am for response number 2, madam.
Yes. In the Bora, it gets for response.
Lordship, deeply obliged.
Yeah, please, Your Lordship. I have a simple prayer, my lord. Lord, all these matters may be disposed of, my lord, the direction that we will submit a representation raising on remand. They will dispose it in accordance with that guideline. Earlier also, Your Lordship passed something.
If they file the representation immediately, Lordship will give us 1 week's time,
Yes.
we'll dispose. Otherwise, Lordship, there has been some facts which were not brought before this court. Petitioners stood released earlier prior to passing of the orders by this honorable court. Secondly, the guidelines which my friend was relying upon, that was modified in the month of March, and the transfers could have been effected till June 30th. All those things are there, but since he is saying that he will file a representation, let it be there. I will not delve into all those things.
Yes, madam. You know what?
He will file a representation within 3 days, Lordship will dispose it of.
Yes,
7
madam.
days
Yes,
thereafter.
yes.
Mr. I. Rafiq will case for the repetition. Then we
Item number 18 and 20.
right in. Petitioner. Silly transfer order issued by the regulator. by order dated 17/6/2026, it's permitted to be instructed. And transfer order was directed to be not even take to till today. It's called that. Mr. Rafiq submits that the instructions submit before the court that the petition the appropriate authority by filing the detailed representation. And once is ventilated by the petitioner in their representation, be directed to be taken into account by the appropriate authority, namely which authority?
That's number 2 million.
Respondent two, Billy.
Sorry, 3. No, 4 million. Principal Chief Secretary Commission.
Respondent number 4, namely the Principal Chief Security Commissioner from the agreement. So, on such representation being filed, it is submitted that the state respondent be directed to by taking into account by passing the scheme. Declares made by the council to commissioner, the CBC, the API, does not object to the prayer made. He, however, submits that the representation be filed
Within 3 days?
within 3 days.
Yes, ma'am.
Within 3 days from today. Thereafter, further period of 1 week, the representation is disposed of by the respondent. Considering the submissions made, the petition stands disposed of with the following order. Petitioners are permitted to file their representation before the respondent number 4, namely for ventilating the advances within 3 days from today. Stop the representation stop by authority concerned within period of 7 days from the date of receipt of the representations filed by the petitioner by passing the speaking order. So any such order that is passed, copies thereof shall be served on the petition. Till the representations stand disposed of as directed, the order will not be given effect.
They already stand released.
Don't give effect
Yes.
for 7 days
Lordship will just make an observation.
until disposal is directed. Not be given effect. Stop. Make clear, even the petitioners fail to file the representation is directed as permitted, then the interim order stands vacated without any further reference to this. The petition stands pulled off in terms of
Only 1 line. In terms of directive number 58, revised. They will consider. In terms of directive number 58. They will consider.
whatever is there.
Yes.
The authority will consider the prayers made in terms of which directive.
Directive number 58.
Where?
Annexure 1.
Uh,
Page 14. Annexure 1.
That has been subsequently revised, Lordship. So Lordship will put it as per the
Relevant guideline.
relevant guidelines,
As
Lordship.
per the relevant guidelines governing the transfer and posting of their what? Railway Protection Force.
Yes, Lordship.
Railway. Which are the matters?
My lord, the next item is only force order number will be 19,
And so item 17, 18,
19, 20.
There we can subsequently,
17, 18, 19, 20.
47, 48,
And
45, 46, 47, Lordship there,
and 48.
48.
45 my lord, similar
40,
matter, and
44.
others has become in process.
44,
44 my lord, here we have challenged the transfer order my lord, so same order will cover.
44, then
And others my lord, 45, 46, 47 my lord. Here I have
48.
challenged the release order my lord, so
The
it
same
become
thing.
infectious.
so become in
Yes. Only 45, 44.
44 is disposed of in similar terms.
Yes,
Then you write 45 to
48.
48 in view of the orders passed in WPC. So these writ petitions are have become infractuous according to the same cell.
Only the force order will be different. The next item, 1989.
Which force order? Which matter?
The second, the WPC number 3224, the next item. Force order will be 19.
No, we'll say the relevant force order.
Yes.
Relevant force order. That's directly providing the concurrent proceeding or failure.
Yes. Deputy order.
And appears for the petitioner when the matter is called up. In the speech Chakravarti, you were there? Water resource. Matter says passed away.
May it please.
Yes.
Matter pertaining to my lord regulation of service matter. Initially, they were appointed as on fixed day matter. Thereafter, there is an order for regularization. Then, my lord, their regulation was cancelled, my lord. Your lordship has issued notice, my lord, in similar cases.
Yes, madam. This matter may be taken together.
We Bora, I think. See,
Respondent number 4, 5, and 6.
respondent 5 and 6. As the for respondent number MS Lurica for respondent. Mr. Raj for respondent number 3. The respondent, the representative.
Yes. Obliged.
May I agree? We have challenged the impugn termination order. Is on page 37.
Appeal,
Dismissed.
appeal,
Page 53.
Brings the inquiry report also.
heard. I think it's 126. And go through. First, or the 60. Take down.
All the rest.
So the way extra copy we furnished is the period of 1 week.
Highly obliged.
Her husband was appointed as a master role on 1/4/1970 and expired on 23/6/2022. Right, annexure 2 request to include is supposed to regularized on.
Why have you come after so many years? Why have you come after so many years?
Some representation was submitted, but
When was the representation submitted?
page 26.
Buttons. Returnable for Mr. Radford. Then council appears for this one, 154. Mr. Radford appears for this one, 5. Mr. Thor appears for 3. Mr. Andoriga for 4. Then our board for response number 5.
Okay, Mark. My lord, I have two prayers, my lord. One is when I was suspended in the month of May 2024, they have not paid me the salary for the month of May. That is my second prayer. My first prayer is that, my lord, they have deducted that 50% and 25%, my lord, during the period of suspension. That amount also they have not paid, my lord. And my lord, I am reinstated. Already they have reinstated. And as per FR 54B, the order of reinstate, there itself they should have mentioned that what is to be done with regard to my that arrears, my lord, 50% and 25%. No order passed, my lord. Reinstated. Departmental proceeding was there. After departmental proceeding, demoted, etc., my lord, and then reinstated. Immediately I am reinstated. As per FR 54B, they should have passed a reason order. What is to be done with that amount, arrear, whether to be paid or not. If not paid, then again they have to give me notice. I have to reply within 60 days to that notice. Nothing done, my lord. So, my lord, I am praying, my lord, let notice be issued, my lord. And my lord, I have challenged the entire departmental proceeding in writ petition number 7031 of 25. This matter be taken with that, my lord.
My lord, let him first supply a copy to the Panchayat department. They are not here, man. Their name also not in the score list. The entire writ petition is against them.
The Panchayat is a party.
Panchayat, man.
Panchayat party.
Party. Copy is
You are
not
under
up.
suspension now.
No, no, man. Reinstated.
Reinstate.
Reinstated, demoted. I have joined and I have challenged the departmental proceeding before this court in another writ petition. Now, my lord, if I succeed in that writ petition and if court holds that the entire departmental proceeding is illegal and quashed and set aside, then they have to pay me the full salary as per 54B. That's why, my lord, I am praying that notice be issued in this matter and this matter be taken with that
Here,
writ petition.
here you are asking for what is the prayer?
My lord, prayer, my lord. Kindly come to the prayer portion, my lord, at page 12.
Area salary.
Yes.
Area salary for which post?
For
Area salary in which post?
accountant, my lord.
Post you were holding prior to being demoted.
Yes.
Panchayat is not here. What?
No, we have made a party.
Made a party ballot, my lord. Copy ballot. Not their name is not there in the call.
Panchayat department. Represented by the Post. However, the list council for the self copy. Standing council. Copy. Standing council. Andoriga. Right. Sir, or you're appearing?
No, my lord. Here, my lord, all departments are of Panchayat.
That will be listed after the return.
The matter will be taken, my lord.
First, sir, copy, let it come, then we'll take it.
Sir, my lord.
Let it be typed on the returnable date. Can be typed on the returnable date.
That case is otherwise fixed on 29th, my lord. That is for final hearing, my lord. That is for
How does it affect the hearing of? They're independent person.
yes, yes. Obliged, my lord.
For pending contract.
Go pass over to me.
Also, my senior is on bench.
to address.
And I am not on the record also. Please engage my.
We'll defer it after the meeting.
Not paying a minimum pension. Then notice may be issued in this case. Only my prayer is
Yes, sir.
connector meter is pending before this one or before minute. Then this meter will take along with the WBC number 3276
Let it be, when is the matter fixed?
17 of July.
17 July.
17 July.
Submitted the similar matters are fixed on 17.
3276
Matter fixed.
3276.
376.
W.
Yes, we have recorded.
Please, Your Lordship. This incident writ petition challenges the inquiry report, the dismissal order, as well as the subsequent appellate order that was passed by the authorities in the finance department. It challenges primarily on the ground of violation of the scheme. Pilot.
Your name?
The handling.
The handling appeal. I have filing. Yes, Sharma for
Agent. One.
for industry. Correct. 1 week.
The other because were on 3rd of July.
Want this matter to be listed on 3rd of July.
23rd of July, along with the other petitions.
It is submitted that
This may be issued in this case.
the matters are fixed on 23rd of July.
WBC
It
3250.
returnable 23rd of July. Mr. P. A.K. votes appeals for all the
1 to 7.
all the respondents.
So, Lordship, 8
1
is
to
pending.
7. MSP Azoriga for number 8. On 23rd of July. Let this matter also be listed along with WPC
3250-2026.
3250-2026.
Lordship.
Yes. I took the instructions from the petitioner. The petitioner seeks my lord accommodation till October because the major part of the classes of his daughter will be over by then.
No,
Practically.
Lordship, other point we have already the last order. The Lordship wants to give only 1 month time to settle his problems, Lordship. So on
Which
that,
will-
Lordship, I will
we
not
will
object,
give you 2 months,
2 months.
60 days.
Lordship.
My lord, just abandoned person, my lord, since he's been released, my lord, these 2 months he may be allowed to be with the unit, my lord.
And undertaking, he may be
And my lord, he will
provided that after 60 days, he will.
No undertaking. We are passing an order.
My lord.
He will be deemed to be released.
Lordship.
Urge Dr. Puti parties before the court challenging the transfer order. 5, whereby the petition is transferred from present place of Sting 160 Italian reconsideration of transfer order that means elder daughter the mid-academic year of class 12 standard in a private school in Gauhati, and his daughter riding with him for year. So his wife
His
Mother.
also not available to the petitioner as she caregiver to the 70 years old mother of the petitioner suffering cancer treatment at Borpeta.
Borpeta.
So here his younger daughter is also with him.
my lord, yes. Younger daughter is at Borbeta. Eldest is.
The younger daughter, mother. So submitted that transfer which however triggered and effective. Would be heard by the government. Because this court is not proceeding. Even accept the fact that his daughter is present. Class 12 academic session. And therefore, sport that the petitioner should be permitted some time to make out his hearing. Accordingly, the stand disposed of directing the petitioner take steps to make all alternative necessary in a period of 60 days from day to day.
Lordship may make it up to 31st of August. Days 24. So it will be better.
Months time be granted. Make then automatically vacated after 31st of August without further reference to the school.
My lord, his leave gets expired, my lord. He may be allowed to rejoin, my lord. Otherwise, he will like.
Take a document order and transfer order to the state, the petition is permitted till 31st of August.
Oh, like.
Please, your lordship. Lordship, instructions are still awaited, your lordship. Lordship, kindly fix the matter to your lordship.
Otherwise, that's it. I have been granted promotion. After 2 months also, they are not allowing me to assume charge of lordship. And there is no provision
Act
of
to you.
Act to the lordship. Okay.
In this case, my lord, with due advertisement lordship, petitioner was, my lord, appointed as Gaupura under
So you filed a review also.
yes, lordship.
That was
As
dismissed.
per order of this honorable court lordship, this honorable
That
court,
was
my lord,
dismissed.
Yes, that was dismissed, my lord, saying that, my lord, only one ground, lordship, that I have no, my lord, landed property in my own name, lordship. Now, kindly see, lordship,
We'll
the
issue notice today.
my lord, till then, my lord, I may be protected. Earlier, you lordship protected, lordship.
You are protected in what sense?
My
What
lord, that order may be stayed, lordship.
And then you are
My
holding
lord, I am
charge.
holding charge, working till now. Yes, no order. Till now, I am
Who's
working.
holding charge?
He is not holding charge, madam.
Nobody.
Who is presently the Gauhati?
Nearby Gauhati is given charge, additional charge.
No order is there,
Can you
lordship.
show us anything that you are holding charge?
My lord, still today, my lord, in terms of the interim order, lordship, the kindly see the order
What
dated
interim order
85,
was
lordship.
What interim order was done?
My lord, I have stated in the petition, I am still holding.
Where is that interim order?
At page 85, lordship. Page 85, lordship. Otherwise, the private respondent is not qualified, lordship.
Where is the order of the review?
My lord, at page 103, lordship. I had taken many of my lord, grounds, lordship. The qualification, academic qualification of the private respondent, lordship, as per RTI report, he just passed class 9, lordship, from the school, lordship. Now, required qualification is class 10 pass, lordship. That was not decided. No order is reflected in that. No decision is reflected in that order, lordship. My lord, only order is my reflected, lordship, that I have no, my lord, landed property in my own name, lordship. Now, in terms of the, my lord, for prescribed format, lordship, my lord, with the advertisement, lordship, the father's land was also, my lord,
You
directed.
show us officially that you are holding posts.
My lord, officially, I have not, my lord, discharged.
Then?
Officially, I have not, my lord,
Then
DC has not
does
been
it
released.
affect- Then what benefit will you get by the
My lord,
interim
DC has not yet released me, lordship.
Below.
Directed to fresh, my lord, issue fresh advertisement, lordship.
Whatever the DC does will be subject to the outcome of the writ petition. So far as the post of Gauhati for that particular village is concerned.
I have, well, I have still, lordship, I have stated in the
Heard,
repetition.
learned counsel. There is the full learned. One and two.
1 and 2.
ZD Burman for respondent 3 and 2. The Bharadwaj for
5.
You are on caveat. Caveat doesn't. Yes, for this 5.
My lord, in paragraph
There are 5 will file the caveat. 5 caveat is done. By the earlier order, dated 28/11/2025 passed in WPC 6756/55. The petition filed with the present petitioner. Petitioner to file a review petition, view application before the authority prescribed regulation.
7/6.
Fine. Here are the council submits that he is the charge of the stock Gauhati and the deputy.
Paragraph 59.
How is it? Such. There is only an amendment. Paragraph
15 motion.
there is petition, the present petition. Start.
Motion.
When
My lord, last sentence motion. However, till today, no coercive action has been taken by the DC against the petitioner, and the petitioner is working. as the-
paragraph 15.
1/5 motion.
1/5.
Lost. Page 11 motion.
Page 11. That is paragraph 15.
Yes, lost. I'm sorry, lost it. My lord, after 14 long, it will paragraph.
That would be state. For number 3, state council representing the deputy price report as to whether the claim proposition that is still functioning as a Gauhati. Whether it is still functioning. Second will be by status quo be maintained by the parties.
As was functioning
By the parties.
of like.
Challenge the appointment of phone number 7. I can share no R. Now there was an advertisement issued in 2023. I can share the invited application for the post of my lord, newly uncadred post of administrative officer, which was inserted.
The appointment, which post?
Administrative officer
Administrative.
under the deputy commissioner.
You are working as a
I am working as my lord, senior assistant.
senior assistant. Third.
Here, your lordship, there is one problem. Here, the rule has been challenged, so it should come.
Rule has been challenged.
Yes,
Basically,
page 80.
we say that my lord, there was a rule was not acted upon, and subsequently, my lord, now they are my lord following the rule. Therefore, my lord, whether rule is my lord very clear, my lord, acted upon or not, that was our
Challenging, declaring the amended provision of the rule to be unconstitutional.
then my lord, she might have to
Heard council party pointed out by the state council that challenge prayer in the prayers made in the are for the declaration, the amended provision of the 6, the bracket 8, the bracket the Assam Ministerial District Establishment Service 1967 has amended 2009, we declare unconstitutional. So appraisal of the proposition is directed to place the matter before the appropriate consent as per the High Court rules.
I pay for response number 3.
The D Bora for response. Mr. S.K. Medi for 4. And the Hazarika for 5.
May I just make a pair for the particular date?
You pursue the matter before the ministry. We'll use the order today.
Mal.
Timing until 5. Yes.
We have received the instruction. We have received the instruction.
What instruction?
Lordship, the eligibility criteria as per the advertisement. The petitioner was not eligible because Lordship, for the post of Sahayat, Lordship. So applications were called from certain numbers of posts only, Lordship, such as casual chowkidar or casual pump operator. But petitioner was hearing was working as a peon, Lordship, on contractual basis. Lordship, on that ground, Lordship, he was not selected as an eligible candidate.
In contrast to that, Lordship, submission made by another friend, the same department in page number 31, Your Lordship might find I have annexed the annexure, Your Lordship, signed by the concerned officer, Your Lordship. It has been written. This is to certify that.
Let him file the
affidavit in order to come to party.
Yes.
On the
Submitted the instruction of the company. File the affidavit. If so advised by the
declare.
Apologies, Lordship. Lordship, here in this matter, I was asked whether they have appeared in the selection process, Lordship. That instruction, Lordship, I'm yet to receive, Lordship. But otherwise, Lordship, to this, the similar benefit they are claiming as per the writ appeal, which was disposed of by this Honorable Court, Lordship, Division Bench. Lordship, that has been put under challenge.
No, we don't know that. Since we had approached this court earlier,
Yes, Lordship.
and by an order dated page 36. Matters to finally disposed of with the direction as para 10.
Yes.
They are given liberty to appear before the committee constituted by Division Bench order passed earlier.
Yes, Lordship.
So, according to the petitioner, this has not been complied.
Lordship, that instruction only I am awaiting.
You should notice the word.
Yes,
Council for Party. Should not.
Yes. Okay. Lordship, sorry, one second. Extreme apologies.
Huh?
Sorry, one second. If I could not
For
not appearing.
raise your colleagues there, difficult to get a better, especially in the closing days prior to the holiday. There are many matters to be completed.
I'm sorry, madam.
No apologies are required. The only thing is that once the matter.
I understand, but problem is this, at the time I was at the start pilot in the other one.
Yes.
The minor, the basically the issue is the minor, the petitioner is being agreed with the minor, the sudden and restrict reduction of his performance gradings by the accepting authority in spite of the higher grading being given by the accepting and reporting, reviewing and the reporting authority for 2 occasions. In the first occasion, that was for the period of
So
that is one
notice will have to be issued.
yes,
They'll have to come back with their instructions then.
because of that matter only that I have been
Without,
two times applied.
giving you notice, that's the issue.
Yes,
Downgraded without.
without informing anything.
Without
And
informing.
moreover, because of that matter illegal act, I have been deprived 2 times from my getting my due promise.
Never.
My lord,
What is the judgment of the apex court?
apex court, my lord.
Devdutt and Shoot.
Devdutt,
If that, if that. Court will be
Devdutt.
stop. Returnable.
Possible.
Persons in lordship order, honorable retired became such as even in written confirmation in the file of Marcus that X. On the foot.
Wins to be ordered. Passed by the court. Dated 12/6/2026. Thereby. Diary of High Court. Clarification. Diary as stated in the minute. It's reported. Right on the dispute arising by the party. Arising out of. Number of the contract works. Work order dated separately for each matter. Be incorporated. So it is.
I'm for the review.
Further review. The copy of this order being communicated by the institute report. Parties will appear before the learned arbitrator appointed on
12/6/2026.
No. You will appear again. When would you like to appear before the
13 or 14
July? When summer vacation is coming up, so there is no summer vacation. Yeah, here on say 5th, 6th or 7th of July.
Can it be on 9th?
9th of July as submitted by the council.
One more humble favor. Earlier in this case, whether the gains I will have even if the Vidyasa have taken over after filing the Ukalatnama also. Still his name is there in the order sheet.
Order sheet, they have got it from the case records of
Yes, he has already handed over.
Don't the name. Mr. Lal's name. Yes.
I am giving.
Also, as per the last order, the written declaration from the prospective arbitrator. See.
Terms of the earlier order. Terms of the earlier order. Whereby Justice Srimati P. Kumari Kukan appointed as sole arbitrator. Prospective arbitrator submitted a written declaration expressing no difficulty and hardship. Act as the sole arbitrator is appointed. Written declaration. Sole arbitrator. Side arbitrate on the disputes arising by and between the parties in connection with business done on the name and style Kamalathi processing dispute and the partnership agreement with the partner. And also there is a supplementary partnership.
5/9/2020.
Supplementary partnership. With 5/9/20. Parties will appear arbitrator on 7, 8, 9, 10, whatever date.
What's it? In date?
You tell us the date.
It will be favorable.
8th of, huh? 8th of July.
8th of August.
What August? July. 8th of July, 2026. Copies of Mark Justice. Good.
Deeply obliged.
One, what's the conflict? Yes, contract and the deed. Conflict in the record. Not very. Contract and the deed. Contract number and the deed.
The IA is for condonation of delay in filing a restoration petition. But the writ petition was dismissed on 23/3/2004, page 61.
IA 164.
IA 2164. Lordship will kindly come to the page number 61 in the IA.
61.
Yes.
in fact, the father of the petitioner has filed the petition. And on 23/4/24, Lordship has passed the order. None appears for the writ petitioner on call. Heard Mr. So-and-so learned senior CTSC appearing for the respondents. Has your Lordship got?
Yes.
On 23/1/2004, 6 weeks time was granted to this granted by this court to the learned counsel for the writ petitioner to ascertain as to whether the writ petitioner needs to be pursued. None is there to apprise the court on the aforesaid issue. In such a situation, this court reasonably understands that this writ petition has become infructuous. However, liberty is granted to the writ petitioner to approach this court for revival of the writ petition if necessity so arises. Closed as above ordered. But in fact, the writ petitioner was the father of the instant applicant. He, page 62, he expired in 1999, 22/7/1999. And the petition was filed in 1995. After his expiry, he's a resident of UP, Agra, and the petition was filed here. The legal heirs of the petitioners are not aware. Kindly, Lordship, kindly for a moment come to para 15 of the petition, page 11. 14, we have said that he was an army lieutenant colonel. He was cashiered from the service, and that was under challenge before the honorable court. The legal heirs have the right to fight it for.
What is he seeking in the litigation? What was his claim?
The dismissal was challenged. If the
Dismissal.
dismissal from service. In fact, it is called cashier, and then with all the dignities and the page 47 is the prayer in the writ petition. I have annexed the copy of the writ petition here. It was prayed, Lord. Kindly come to page 47, the prayer portion of the writ petition. The respondent to show cause as to why a writ in the nature of random or certiorari and or any other appropriate writ, order, or direction. The findings of the finding and sentence dated 7/9/94 of the learned General Court Martial Convent and Narangi by order of the respondent number 4 dated 7/1/94 holding the petitioner guilty of the charges brought against him and sentencing him to be cashiered and to suffer rigorous imprisonment for 6 months shall not be set aside and passed, and why the petitioner shall not be restored to his rank and service with all the benefits admissible under the law. That was the prayer. But the delay we have
No, now as a son,
Lodge.
what claims, what benefits?
But kindly come to para 14.
Where is the writ petition?
Writ petition I have annexed. Kindly see that it starts at page 18. Annex 1. 18.
1.
Yes. This is the certified copy we have obtained from the registry. The petitioner, the applicant was not aware of the proceeding at that point of time. In fact, here he prayed for enforcement of his right, and the findings arrived at the General Court Martial have been challenged. He was cashiered and directed to suffer rigorous imprisonment of 6 months. Without following the due process of law, the Department of Proceeding the inquiry, it was done, and it was inflicted the major penalty. Cashier is the punishment in the army, which not only removes him from service, but also takes back the entire owner, everything takes it without any service benefit. And it was because of the charge sheet is annexed in the petition. Yes.
Now, how did you come to know after 22 years?
That I have explained in para 15. Para 15, 1/5. Page 11. Delay has been explained here, kindly permit me to read, The applicant father expired on 17/7/1999. That the applicant and his family members were unaware of the proceedings pending before the honorable court, and the same was not in the knowledge of the applicant. The applicant begs to state that much after the death of his father, who expired in July 1999, the applicant came to know that his father during his lifetime unsuccessfully assailed the order passed by the authorities by filing a petition before the honorable court. No one knows
the exact position as regard what has happened or what was the order passed by the authorities against his father and the status of the case. At that point of time, he was 20 years age, 20 years of age. Out of his curiosity, the petitioner made several inquiries, and after a lapse of considerable period in the year 2022, he could come to know that his father had filed a case before the Honorable Gauhati High Court, but the outcome of the same was not known. Thereafter, the applicant contacted the local council of Agra, UP, seeking legal advice to proceed in the matter, as he have no contact in Guwahati, and requested his local council to explore possibility to get the details of any litigation which had been filed by his father. Dandamala, the applicant is a resident of Agra. It is not possible for him to get the whole information regarding the status of the case. However, in the month of October 24, his local council informed that his father has filed an application under Article 226 of the Constitution of India, and the Civil Rule number 436 of 1995 before this Honorable High Court, and Mr. G. Roy, advocate, he is presently a senior advocate, was conducting his father's case. The applicant stated that thereafter the applicant somehow collected the contact number of Mr. So and discussed with him regarding the case over phone. It is stated that the runner's counsel could recollect of filing of a case on behalf of the army on behalf of an army personnel, but due to lapse of time, he forgot the details and records of the case was not traceable at his office.
Release notice here,
Lot.
the IA 164.
Lot.
Heard Mr. Deepak. Only respond.
For all this.
Five minutes.
Only that's
Only on the delay.
on your delay and lot of returnable. Lot. Okay.
The last one I'm added information.
Reference in pursuance to the order dated 20. Term to rising by possible. By the communication dated 26, 2026. The as is required under section 12(1) of the arbitration. 6. It's not expressed any hardship. It's difficulty. Acting as the sole arbitrator. Disappointed. Respect of the right. here to do the arbitrator on.
Vacation, my lord.
Vacation,
Or after vacation.
not after vacation. 10th of July. 10th of July, the that wait upon the arbitrator upon. Proceed with the matter. The application petition stands. Right.
Lordship, I am appearing for respond number 3 and 4, Lordship. Lordship, I beg apology, though I have prepared the affidavit, Lordship. I am yet to receive the signed copy, Lordship. So I just may be allowed 2 days' time, Lordship.
Otherwise, the resolution is on record, Lordship.
Not only resolution, Lordship, there are other things on last occasion, Lordship, an order was passed, Lordship. So we want to bring all these things on record, Lordship.
Mr. MP Sharma, petitioner. That,
3 and 4, Lordship.
the above respondent.
Yes,
will be filed within a period of 1 week.
Yes, Lordship. Fine.
During the submission, if this matter be listed,
Lordship,
ensuing
Lordship.
applications by the registry on the date to be fixed. Respondent petitioners are also permitted to file their rejoinder to such an affidavit as may be filed with the state. The DBORA 1, 2, and 4.
Right.
My lord, here on the last occasion, my lord, I took time, my lord, to receive instruction regard to the, my lord, education qualification of the private respondent. My lord, in this regard, my lord, the petitioner, my lord, she approached the, my lord, headmaster, my lord, but he did not, my lord, provide, my lord, any information. So, my lord, he is going to file a RTI application. I need some more time, my lord.
Lordship, the school certificate I have annexed in my interlocutory application, Lordship,
IA.
in my IA, Lordship. It shows that she was reading in class 10, class 9 pass.
What is the requirement?
Class 9
Class
my
9
lord.
pass.
But, my lord,
School certificate regarding private respondent.
Lordship, Lordship.
but my lord, my instruction, my lord, though I have not the, my lord, proper evidence, my lord, that time I took time, my lord, that she was reading in class 9 and she left the school while she was reading in class 9.
No, promoted to class 10, Lordship.
So, my lord,
IA number 3760.
Yes. Page.
Lordship, page number 12. Page number 12 is the type copy. Certificate by the headmaster of Tarabari High School. She was reading in class 10. Thereafter, the board certificate, Lordship. She was registered as a student of class 9 in the year 2002. And this certificate is issued.
it was the next page, my lord, page 14, my lord. This is the registration of
Registration.
class 9, my lord.
9 she has passed. And she was promoted to class 10 also, Lordship. This is the examination record, Lordship, I'm holding.
Page number.
That is not annexed to my petition, Lordship, but I'm holding the report card, Lordship.
The examination report.
It is written promoted to class 10. 9 she has passed. Otherwise, Lordship, I have all the requisite qualifications, Lordship. That is why I was given the promotion. Joined in the year 2011 as Anganwadi helper. I was rendered 10 years of service.
Pending or disposed of?
Disposed of, Lordship. I was impeded.
Statement.
What remains? It can't be kept alive and with an interim order.
Fine.
Then we'll vacate the interim order.
Lordship. Promotion order is not given effect to Lordship. That has been kept in a file.
Examined immediately after vacation last one date, my lord, maybe given.
But interim
My
order,
lord, no instruction.
why should the interim order continue?
So for the instruction
When
is
the
required,
instructions are not coming from your end, on what basis are you getting the benefit of the interim? On the hope that some instructions will come. If it comes, it comes. It's done. There is no instruction. To the contrary.
My lord, the petitioner, he approached the my lord headmaster, but
Lordship. All my documents have been verified, Lordship, by the authority.
These are available. The details are available with the board. Board of Secondary Education, the details are available. If it's not giving, you can get it from them. But
yes, sir.
MDB.
MDB,
5.
5.
1.
The petitioner before this court submitted an application. Parmai Bheti Body Center. They host other than expired on 26/9/20. Available. For student admitting dated 9. For the review. Make it. Private respondent. 4.
Number 5, Lordship.
Number 5. Eligible apply for the submitted the candidature in terms of five was selected and she was promoted by
Yes, Lordship. 30-10-23.
Page.
Page 36, Lordship. Of my affidavit in opposition.
The promotion order was passed after the interim order. So there was a contempt petition, and in the contempt petition, they have that order they have kept in advancement.
An order for Rose Sultana
Rose Sultana.
was issued on 30-10-2023. So the petitioner is for by this petition is for 20 or 22?
22.
20.
My lord, the writ petition I have challenged the my lord advertisement. My prayer is that my lord that advertisement should be a general advertisement so that I can also my lord apply my.
the following, my lord, fill up the post by way of promotion.
Where is the
Those who
advertisement?
can fulfill the criteria, lordship, you should be promoted, lord. Criteria are mentioned.
The petitioner approaches court challenge the advertisement. Petition. Challenging the advertisement. And
1911.
this court
Page 18 of my writ petition.
by the dated 5/12/2020 directed to the Gauhati worker in 46 number Paramai City Study Center shall not be filled up by any other. Submission of the that by to be five by order dated
And I think.
then confirm.
Yes. Approval was given. And by order dated 17 January 24, lordship, she has been directed to serve her duty as Anganwadi helper because of the order passed by the on 5/12/20.
The promotional order is kept in abeyance till disposal of the case.
By which order?
My lord, there, page 20, page 32, my lord, and actual D of the affidavit filed by the department. My lord. Page 32.
Five does not satisfy the criteria for qualification. The private respondent, the class 9 examination and private respondent. 5 on the other hand has filed an affidavit whereby certificate is to class 9. Such circumstances. Further time to complete the instruction is submitted to the school authority respondent. Best to furnish the required information. Where a prima facie is school to the satisfied requirement. As for the conditions seeking for promotion to be used to worker. So therefore, scope of the review that since no information has come from the petitioner, then modify permitting the petitioner to be used for the worker by the related so and so, which however shall be subject to the outcome of the writ petition. The writ petitioner is permitted to complete the instructions and apprise the court with regard to the claims made by the writ petitioner that the private respondent does not fulfill the requirement.
And the student number 5 be permitted to promote it, lordship.
There we will modify it.
Lordship.
The respondent number 5 will now be permitted to serve as the Anganwadi worker in terms of the order dated release this matter after 4 weeks.
Kindly adjourn it to the next day.
Submitted, prayer is made for seeking adjournment. Counsel for appearing with the respondent. Take to be prayer made, release this matter again after 4 weeks. MSP will appeal for the PTC authority.
My lord,
What is the manner in selection? How was he selected? I mean, how were the markings and everything? Is there any information?
now, my lord will, how were the marks, my lord, given? That I don't know about marks. Whatever marks, my lord, is there in this, or in annexure 5, page 27 of the writ petition, my lord. My lord, here the thing is that, my lord, two things my lord has to take into consideration, my lord. May I, my lord? My lord, one is that there is no prayer for setting aside the advertisement. Because in the condition of the advertisement is that, my lord, she cannot be a regular student. That is, my lord,
What is the marks allotted is page 27?
27. The writ petitioner is in serial number 6. She secured 326. And the second next is, my lord, 319, number 1.
She's BA, DLID, DLED. It's mentioned also. What is it? It's 27.
Now, Mr. Dhor,
My lord,
if you come to page 27,
my lord,
marks being offered,
my lord.
education qualification, it is shown there. There is one more candidate who is a BA.
My lord. Here the issue is not about BA, my lord.
Ah.
Here,
Regular student.
no, she is not a regular student, my lord. The serial number 1, who is a BA, she is not a regular student. But the writ petitioner is a regular student and she did not disclose that she was doing BA.
It's the writ petitioner.
Writ petitioner is number 6. Serial number 6.
Okay.
Here we are not about BA, my lord. Here,
Regular student.
regular student, my lord. She cannot be a regular student. And that is the part of the, my lord, advertisement and a notification under 309 by the governor. So, my lord, unless these two is set aside, my lord, we cannot go beyond, my lord. First, my lord, have to interfere with the advertisement that is not under, there is no prayer. That advertisement condition of that has to be set aside.
No, but we want to know that she was a regular student on the date of selection.
Date of advertisement as well as selection. Both.
Where is the order of rejection?
And last page. Page 31. Down below, endorsement is there. Approved, accept serial number 5.
31.
31.
No, there is no specific order passed.
No specific order is there.
No, my lord.
There is only endorsement, approved, accept serial number 5. And serial number 5 is the petition. The final selection.
Where is the condition in the advertisement?
Advertisement condition is, my lord, in page number 22. start from the advertised, starts from 21, that is the my lord translation copy. And page number 23, my lord. And in page number 23, serial number 9. The regular student of a school or a college shall not be considered for the said post. My lord will find the vernacular in page number 25, serial number 9.
The requirement was HSLC passed. I was not a regular student of HSLC, HSSLC, that is higher secondary. I passed HSLC at that time, Lordship. Advertisement was published in the year 2023. I passed HSLC in the year 2021. And after passing HSLC higher secondary, I cannot sit idle, Lordship. I take admission in BA courses, Lordship. And till the selection process was completed, I completed my BA, Lordship. It is not that in the meantime I was appointed and my studies hampered in rendering service as a Anganwadi worker. That is not also there, Lordship. I was not, point is that I was not a student of higher secondary. Already I passed that, Lordship. Can someone sit idle after passing higher secondary or passing some exam? If she or he has other aspiration, Lordship. Had I a student of higher secondary, matter would have been different. But I, the required qualification was already there, Lordship. And Lordship, it is a preschool, Lordship. And preschool where the infants are, Lordship, guided. Petitioner from the merit list, it is sent that petitioner is more meritorious than others, Lordship, having good career, Lordship. So if in such schools, such meritorious candidates are appointed, I think that would be better, Lordship, for better upliftment of the kids, Lordship. Moreover, my application was not rejected at the time of preparing the comparative statement. After preparing the final selection list, only that adjournment was endorsement was there that approved at serial number 5. Only that was there, and that was also not communicated to me, Lordship. That was not communicated. When others were appointed, then I pursue with the issue and got to know that I filed RTA application also. I came to know that for that reason I am not approved. And no candidate made any complaint, Lordship. The president of the management committee of the Anganwadi Center was the complainant.
He was a member of the selection board. That president was a member of the selection board.
No, my lord, he cannot be. PTO, medical officer, my lord, who are the board
Member
members, my
secretary.
lord?
CDPO.
CDPO, district social welfare officer, PTO, and medical officer. These 4, my lord. These are all government officials.
Is there any comparative statement available? I mean, how the markings are allotted?
That is not there. But my whole submission is that we are sticking to the advertisement, my lord, and the notification by the governor. Because we have a set of rules. So unless that rule is there, my lord, that rule is not modified, my lord. We have to stick to our rules. The rule says that, my lord, she cannot be a regular student. So, my lord, while
This is not something which is raised by the selection board.
My lord, why? Because she, my lord, while applying, she did not disclose. She did not disclose that she is a regular student, my lord. So my lord, we could not have gone. Somebody has raised it.
That option is not there in the standard format, Lordship. Standard format is silent about that option, Lordship.
My lord, thing is that when there is a condition, condition precedent, my lord, that no regular student will is, my lord, it's permissible by this advertisement manner. She should not have applied. Or she should have, my lord, given up her.
So now on the date when the selection is made,
My lord,
she's still a regular student.
she is a regular.
On the Lordship, may kindly see my
She was a regular student, my lord, on the date of
kindly see
selection
my
date.
BA pass certificate, Lordship.
Where is the certificate?
Pass certificate, page 19, Lordship. Certificate dated 14/8/2024.
And date of examination, my lord.
Next, I have annexed the examination schedule, Lordship. Next, page 20, Lordship. Examination was held on 20. No, Lordship. This is the mark sheet, Lordship. 22/7/2024. And I have annexed with the examination schedule in my affidavit reply, Lordship. Page 59. It was held from 21st of May 2024 and concluded on 29th of May 2024. And the comparative statement was prepared, yes, Lordship. Comparative statement was prepared on 24/6/24. And the finance selection list was published on 15/7/24.
Where is
Meaning
the comparative statement? We'd like to see how the markings were given.
Well, that
Is there anything available?
that was never called for, because that is not an issue, my lord. So this, if my lord direct, you can always bring it, my lord. But my lord, here the issue is altogether different, my lord. We said that, my lord, she is not eligible to sit for the exam. Was the advertisement, my lord, is very categorical that she cannot be a regular student. While applying, so she has
We want to know
hidden it, my lord.
how many. These are the only candidates available, is it? Or there are some other candidates? That page number. These are the candidates for the same post, isn't it?
Page
My lord.
27.
My lord.
My lord, I was a student, a regular student, but
Where is the complaint lodged by the president or whoever it is?
everything in opposition filed by my learned friend.
It is in page number
51.
51, my lord.
One.
My lord. In excerpt C, my lord. The particular is in page number 52.
third day Lordship might have gone through the judgment.
We'll pass on. One second.
That's
At 2 p.m. We'll come back in the second half.
well. Judgments I party.
Heard. Take it. No, but your minimum.
President of school management.
President of this. What school?
Anganwadi center management.
The Anganwadi Center Management Committee. That her appointment, her selection, violation. Candidate cannot be. Right. Application was submitted. Inquiries were made by the by the a communication was for a college authority that where is the certificate of the college?
Page number 53 of the
College
Edition letter.
certificate page 90.
For a college. That. Good. Or so that. The article. Right. Director. That. regular student at the time of interview. Selection. Guide, the condition pendant to the advertisement. Specific. As per the advertisement. There is clear restriction. Student of a school and a college. Regular student of a school or a college selected for
And it's backed by a notification.
where is the
Page number 38.
council. Application.
January 2019. But 39, my lord.
Where under the where there is a specific provision, action of candidates on the ground. Support of something referred to and relied on judgment or plus one. Support of higher profession of higher qualification. Can the judgment you rely on? Shiny.
No, he was Monsuri. He was Monsuri.
Council. Referred to with kind of use that. Paragraph B.
Paragraph 64 and 65.
Submit that where the essential qualifications are satisfied. Candidate or not take it ground or using higher quality. There any judgment you are relying, Mr. Law?
My lord, I have already given that general manager versus deputy general manager, disciplinary authority.
Huh?
While judgment.
You are placing it now.
No, I have placed it
Earlier.
file.
What is the name?
General manager versus deputy general manager. That's a my lord, downloaded from Supreme Court of India's website. Man.
Our contract. Our court has referred to the.
Para 9.
So this is K. Pubasar.
Yes, ma'am.
The same judgment is referred to.
Not referring.
Yes, it referred to.
I refer.
You relied on the judgment.
No, Lordship.
What are the judgments you relied on? Mansuri and?
Y Srinivasa Rao,
Okay.
paragraph 6, Lordship.
Person,
Over-
why
over-
Srinivasan by you?
Yes, Lordship. Paragraph 6, Lordship.
Person, right on why Srinivasan now? 1992. Yes.
May I point out one thing, Lordship? I'm sorry. May I point out one thing?
First, tell us the judgment, which judgment you
Paragraph 6 of Srinivasan. Lordship.
6.
6, paragraph 6. May I read?
Submit that. It's objective to contentions with that. That preference of uneducated person or educated person amounts to allowing premium on ignorant submitted that therefore mainly because the person, the petitioner is a regular student pursuing a BA degree which he has in the time completed, that cannot be a ground to reject her. She is
Other one is
yes. What do you want to submit?
The other one is Firoz Lordship.
Yes, yes.
And also I am regarding the citation given my learned friend Lordship. It goes against my learned friend Lordship. There is a capping Lordship. There is a capping. The standard requires a 10 to 12. And here it is beyond 12. That is my humble submission. Lordship.
Explain. That the option to declare correct information. Fact that the petitioner had been pursuing BA degree as a regular student. And thereby requirement verified. Examine every time permitting the petitioner to
That one point of thing that
join the counsel with the petitioner submits that the facts and circumstances, the judgments, the apex court, relied upon by the respondent, not applicable, and the conditions therein are different from the conditions applicable here. Submitted that the application form, there was no furnishing information as to possible. Back, anything else?
My lord, two things, my lord. The writ petitioner did not challenge the condition of the advertisement and the notification.
Right, January?
23 January
23 January 2019, prescribing specific ground for rejection of a candidate being that specific ground for rejection of the candidate that the candidate should not be a regular student and which is reproduced in the once application is by the government, the respondent authority that is by the triggers specified. Unless there is a challenge, this court interferes that permit such proceed with selection process contrary to the conditions prescribed in the get her higher secondary education. The year 19,
21.
21. Well, for example, so, but Rakilda,
Rakhalkilla, Pashchim Bengal.
Rakilda Pusti. That candidate shall not be a regular student, school or college. The affidavit which is then posted. Narrative statement. Stream. By 87. Statement that education qualification or the candidates are that BA
HS, serial number 6,
Okay.
HS.
Rejected as H. Second position. First. Second. Subsequent final selection list of the Anganwadi worker under the right. So includes, which includes 11 button centers and candidates who are chosen in respect of 11 button center. So all the candidates shown in the first position. So specific order has been issued. And endorsement is seen across the final selection list. Indicate that the list except serial number 5, which lists the name of the victim. Submit was up by notification dated 2019. Write down the eligibility criteria. Where at clause 4, provided that the candidate should have the qualification just pass from the higher secondary. Grammar. So far as facts of the present petition are concerned, described under the that candidates even accept that under the section of candidates of the following regular student of a school or college who is one of the license of the facts as pleaded by the parties to the court is clear that the denied otherwise satisfies all the norms. Successfully. Candidate reached the first position. Chairman, Party Center. First time of the selection process and input. the requirement. Since the essential qualification in higher secondary pass, they indicated the same. The form supply. And since there was no other problem, enabling a candidate to indicate higher qualification, achieve the first. The candidate by any candidate who had participated in the selection process or the selection of the by the selection committee. Achieving higher qualification. That a complaint made by the chairman effect that the chairman has to be appointed. So, not only even the chairman completed her BA degree
Certificate dated 14/8/20.
14,
8. It's 19.
8,
19.
14, 8, 22. Final selection was on 15/7/20. Therefore, that on a date when the selection date, other person has been appointed, said post. Anyone appointed? No other person has been appointed. Time will help to
Sorry. 20.
12/2/2020, which is the skill subject. Fully correct and pointed out by the state of by January 2009. And also, conditions mentioned in advertisement are not under challenge. Where is that application form? Is it available somewhere? You have pointed out somewhere? One copy you give. The application form was not enclosed to the writ petition during the course of the hearing. Being permitted by the court was placed before the court, kept in the case report. The application form clearly reflects that the writ petitioner higher secondary. Serial 7 of the application writes for other qualifications, which has been left out blank. It query by report the council of commissioner submitted that the application form was submitted on 8/12/2023. At that date, she had only completed her secondary, and though she was undergoing the BA course, she had not yet completed. Therefore, vision that she had obtained the BA degree time when the application form was filed. So, scrutiny of the application form, which is in the document, reflects that there is no specific provision. There is no specific information. There is no specific, there is no provision for furnishing any specific information whether the applicant is or is not a regular student in any institution, including school board. The question therefore is the interpretation of the laws. It's regular student of school or college, which is ground for rejection of the candidature. So, there is no explanation which can be discerned, which is discernible from the notification dated so and so, as to the rationale for rejection of candidates who are regular students. So perhaps since the application is for seeking for employment in the Anganwadi center, it naturally follows that a regular student will not be able to perform her duties. Therefore, the authority will be within their rights to lay down a condition for rejection if it is found that on the date of selection and appointment, the candidate is a regular student, therefore will not be able to undertake the responsibility of the body center. So, yeah. However, in the facts of the present case, on the date when the selection proceeding was undertaken and the final list of shortlisted candidate was issued, and before any appointment orders could be issued, the petitioner had already completed her graduation. So, by virtue of the interim order dated so and so passed in this writ petition, no appointment orders were issued to fill up the post. So, there was no appeal or an application seeking vacation or modification of the interim. and the interim order still subsists. As on date, the writ petitioner had already completed her graduation, and she is not regular student in any college or college as submitted by the petitioner. So, as discussed above, candidature of the writ petitioner, say, by any other candidate who had also submitted their application before the authority for the selection of the list of Anganwadi center. The ground that the selection is initiated for any reason. The complaint is lodged by the chairman of the Anganwadi center, Anganwadi Management Committee. The ground that the selection of the candidate is violative of the condition mentioned in notification. Read with the conditions prescribed in the advertisement. So, coming to the judgment of the apex court, just into service. By Srinivasa Rao, the issue before the apex court was the selection and appointment to the post of leader of a fair price shop in the state of Andhra Pradesh, following an advertisement, where one of the conditions was preference be given to unemployed educated youths, ladies, handicapped persons, in case of equal qualifications amongst candidates. So, the appellant before the apex court was shortlisted as a candidate as he was a graduate and was also a fair price shop dealer for a long time. This was challenged by the candidate who was by the respondent before the apex court, the High Court, and the writ petition was allowed by the single judge, learned single judge, interfering with the appointment of the appellant before the apex court, and which came to be confirmed by the division bench of the High Court. Before the apex court, judge that there was no guideline indicating the nature of interview, which is to be said to be the sole basis for making a choice for the settlement of fair price shops. Judged before the apex court by the respondents that preference should be given to less educated persons as they are handicapped by reason of lack of education as compared to better qualified applicants. So the apex court rejected the contention. Held that the decision to prefer an uneducated person over an educated person amounts to allowing premium on ignorance, incompetence, and consequently inefficiency. So, the apex court held that the only fault of the appellant was to have pursued his studies beyond class 10 of the school. Had he discontinued his career as a student, he would have been running the shop today. This was found to be amounting to gross arbitrariness and therefore illegal determination. It was held by the apex court that pursuing this line, the state will have to be going in search of more inefficient person, and it is not known where the process will end. The relevant paragraph is stated below, para 6. The appeal preferred by the shortlisted candidate, therefore stood allowed. The judgment High Court set aside. So, relevant paragraph, para 6. It will be apex court held that apex court rejected the contention of the appellants before the court that six one of the Ada rules framed under the Pharmacy Act of 1948, prescribing minimum educational qualification as diploma in pharmacy, and that such prescription cannot be construed as an essential qualification so as to exclude candidates possessing higher qualification in the same discipline. Had to be known the Act and the regulations which operate in the field of professional regulation. court ultimately held that there is no absolute exclusion of a graduate or a postgraduate degree holder. Stop, they remain eligible provided they possess the essential qualification of the law. Judgment on the testing the service of the petitioner is very applicable to the facts of the case as the rejection of the candidature of the petitioner or non-issuance of the appointment order of the petitioner is not on the ground that the petitioner possesses a higher qualification, BA, than the prescribed qualification, I submit. The rejection, the ground that the petitioner was a regular student in Gwalpara College. The time when the interview was taken. Having noticed the judgments which are pressed into service, it is clear that the minimum eligibility criteria so far as educational qualification, high secondary, which is prescribed both under the notification dated 25 January 19, as also the advertisement dated 12. So, the ground for rejection on respect of the petitioner is that she was a regular student of Gwalpara College at the time when the interview. So, the rejection is also not on the ground that the petitioner possesses higher qualification than the eligible qualification, than the required qualification, eligibility is prescribed as the eligible qualification or high secondary. So, prescription of rejection of a candidate for pursuing for being a regular student under the notification dated, if applied literally, will mean that the state has discouraged candidates from pursuing education, and more particularly girl students, when education has been recognized, right to education has been recognized. Any attempt by any candidate to pursue education and enhance their qualification by securing higher qualification cannot be a ground penalizing such efforts. So, as discussed above, the condition which is prescribed under the condition of being a regular student of a school or a college, which is prescribed as one of the grounds for rejection, does not provide for any further explanation as to the rationale as to why such a condition was found to be necessary by the state to be incorporated in the notification dated. In the absence of such explanation being furnished in the notification or the affidavits filed, this court, it is the view of this court that this condition will have to be restricted, mean that on a date when the appointment order is issued, the candidate ought not to be a candidate pursuing regular course and a regular student as the same will be a hindrance in rendering her service as a full-time and-body worker or helper selection. So, facts of the case. As on date, no appointment orders or rejection orders are issued. Rejection order will be petitioner in appointment any other candidate by virtue of the interim order passed by the court. And the petitioner is also not a regular student. She had successfully completed her BA degree and so on. Therefore, this court is of the view that the rejection or non-selection of the candidate by virtue of the fact that she was a regular student at the time of the interview if permitted to be used will be contrary to the provision and the abode object of a modern state where avenues of appointment with the government are substantially rare. So, under such circumstances, this court allows the writ petition, directs the respondent authorities to proceed for the appointment of the writ petitioner by passing consequential orders. So, it stands merged with petition allows disposal. No time frame. Disposed. Yes.
Here the respondents were directed to through any provision, whereby the even after issuance of the promotion order, they can by subsequent lordship GFC or some court must procedure, whether they can stop on that question was, that query was put before the lordship respondents to bring the record. Whether there is any provision even after issuance of
Yes,
the
yes, any instructions. Maybe tell us what is
But
this?
in the, there is an office memorandum, my lord,
Uh.
where it is stated that case number 13, my lord, when a government servant comes under a cloud, he may pass through the 3 stages, namely investigation, issue, transit, and departmental proceeding, order prosecution for criminal charge.
Page number?
Case number 13.
Huh?
13.
1. Then paragraph?
In paragraph 6, my lord.
6. Then
Here, my lord, when a government servant comes under a cloud, he may pass through 3 stages, namely investigation, issue of search, seat and departmental proceeding, and prosecution for the criminal charge, followed by either the penalty, conviction, or exorbitant acquittal. During the stage of investigation prior to the issue of charge sheet in disciplinary proceeding or prosecution, if the government servant is of the view that the charges are serious and the officer should be promoted, it is the offense of the government to suspend the officer, which will lead to the DPC. My lord, in this case, my lord, the order is of there is no suspension order, but in page number 23, my lord.
here there is no order as on date.
No, no order, my
Then
lord.
why are
Only
you not
GFC
allowing him to join?
There is no order, my lord.
Then
That only GFC is for
the contemplation is no order.
yes, ma'am, that is there is no order of
It's, what are the judgments you are relying on?
Yes, no, I am relying on the judgment of A.V. Janakiraman. And Lordship, I have already given one the judgment of Union of India versus Kumar Sarkar. And Kumar Sarkar has also relied on the judgment of the Lordship clearly said that at the time of the DPC, considering the case for
No,
promotion.
no, in your case, there is no DPC.
No, DPC was there after
It's completed,
completed, yes.
exonerated.
Yeah, but in Janaki Raman also it is said, you can put in self cover if there is, if there is anything.
Third learned counsel for the party, the petition. Petitioner before this court. As I say, has sought for a direction to be as follows. That in spite of, but despite the order dated, what is the order?
13, page 50, 50,
Page 50.
Lordship. 13/4/2026.
Despite the order dated 13/4/2026.
Lordship.
Promoting the petitioner
Inspector, to the rank of
to
inspector.
the rank of inspector. He is not allowed to assume charge on the ground that some departmental proceeding is again contemplated. Is it departmental proceeding or what?
CFC, madam.
CFC. General for
General Court.
Some proceeding under the General Force Code is contemplated, although no such orders have been issued. And the constitution of the Force Code and the Force Code has also not proceeded to issue any orders requiring the presence of the writ petitioner in such proceedings. So, it is submitted that earlier there was a departmental proceeding against the writ petitioner, which was concluded, and the petitioner was exonerated.
Page 25. It was not against me. I was a witness on the near witness.
The
It was not.
departmental proceeding
He was
was initiated against another person, another employee, whereby the petitioner was
a witness merely.
called as a witness.
And page 25, exoneration is there. Page 25.
And at page 25, where is the exoneration?
That is not exoneration. The clearance is there.
Page 25.
Bold letters.
Sorry.
Bold letters.
The petitioner has submitted that the department has issued DE/DIG vigilance and integrity certificate. That no DE vigilance case is pending or contemplated against the writ petitioner and his integrity is beyond doubt.
Thereafter, promotion.
Thereafter, the promotion order was issued, dated
13/4/2020.
page number
Page 50.
dated 13/4/2026. In spite of that, order being passed, petitioner is not permitted to assume this charge. By earlier order dated 22/6/2026, the CBC was permitted to obtain instructions. CBC submits that as on date, no proceedings are on instructions that as on date, there are no proceedings initiated against the writ petition.
On 23/6/2006, madam, that was initiated, madam. Page number 23, madam.
After the honorable
After the
court
order, madam.
After honorable
That
court
is
order. Exam.
23 is what?
Page number 23 of my instruction, madam.
Order
dated 23/6/2026, madam.
What is this?
That is, madam, in reference to the convention order of assembling GFC under rule so and so, rule has been issued on 23/6/2026. Both accused will be tried jointly before the GFC in respect of their respective charges. Charge sheet dated 15/5/2026.
The charge sheet has been issued.
Charge sheet has been issued, madam. On the as per this record, madam, on 15/5/2026, madam.
So why do you say no proceeding is pending?
No proceeding is pending.
So, but this charge sheet is issued against you.
Then it has not been served to me till date. Now, at this order, as I can see, Lordship, at this order, the distribution, Lordship, in the next page of the order, Lordship, 23/6/26, distribution. The Lordship got the distribution to whom it is given.
Yes.
At serial number 3, there is ASI on 23, day before yesterday only they have.
No, they have issued this order,
Yes.
but charge sheet,
No, charge sheet, they have never issued anything. No charge sheet, nothing. And even on the date of that DPC also, there was nothing. Therefore, they have given the clearance.
then the CGC submits that as on date on 23/6/2026. The general force court has been convened and proceedings will be initiated against the writ petitioner and another.
They are all after the notification of the promotion order. And
According to the writ petitioner, no charge sheet has been issued. But charge sheet has been issued, not submitted.
not
Huh?
That has been issued but not hand over to him, my lord.
How do you know? From where do you say?
My lord, because from page number 23 to 24, distribution of no,
According to
sorry,
the-
my lord, sorry, not that is, my lord. It was issued on 15/5/2026, my lord.
Was it served on him or not?
No, my lord, that is
I disorder, Lordship, I can see that I disorder here. I got 25 after.
Have you received it?
I don't
No,
have
I have
instruction.
not, I have no instruction, but just right now I am got this.
I don't have that instruction, my lord, whether that has been handed over to him or not, my lord.
Lordship, even if it is, then Lordship, then also Lordship, the promotion order is up to 13/4. Even clearance, everything was given. Then how can the Lordship issue that?
No, if the charge sheet is issued, then it will not be given. Your promotion order will remain state.
Promotion order was given after vision.
Maybe, but now if a charge sheet is issued,
But they have not given it.
we don't know that.
Till now, they have not given.
Charge sheet has been issued. He submitted that the learned CGC submits that by the impugned order, dated by the order dated 23/6/2026, the force code has been, GFC has been convened, and it is reflected in the GFC that the proceedings will be initiated on the basis of the charge sheets, respective charge sheets dated 15/5/2026. They submitted that in view of the office memorandum dated 2nd of November 2012, in the event any charge sheet is issued and disciplinary proceedings are pending, the authorities are not, the promotion order of the writ petition will not be given effect to. Is there anything to suggest that, but these are with regard to issuance of vigilance clearance?
Vigilance is not
Is-
given, my lord.
It's already given.
But my lord, from the department from Lucknow unit, my lord, in my paragraph number 2, my lord,
Oh.
page number 2 of my instruction, my lord.
Like the present department is asking for the, is there any vigilance, but we have not received any instruction on this regard, my lord. Page number 2 in para 12, my lord, Roman 12, we have stated that, my lord. The finding topic,
Govinda, I think we can't dispose of this matter.
In the interim, I may be allowed to that. They may proceed. That is because they they have not produced anything. They have not given any.
The interim order, what is the point in giving an interim order? What is the point in giving the benefit of a promotion on an interim order?
That's if they are out, it may be made subject to the outcome of the GFC or the honorable court's petition, because I am suffering after 2 months also when everything has been considered by the DPC. Now they are subsequently.
No, they have not. They don't have the instructions available here.
But lordship can from the record, lordship, it is prima facie. It is.
These are your records. We need the instructions from the department.
But department also, even if let's say departments that 2012 notification and own departments project circular is there. That is the circular. Providing the
No, we
circular.
can't help you.
Providing circular of the department ITBP's
You
department.
come back after the vacation. We can't help you.
Lordship, he will face if required. He will face. There is nothing, lordship. It may be made subject to the outcome of the.
We are not getting the instructions necessary from the respondent. Let's put it that way. And you have approached this court on 22/6.
Yes, I have approached on 20. Because
When
I
was the promotion order issued?
on April, and I have been writing that they have not replied.
Writing is all right, but you have approached this court on 22/6.
Lordship, I have
The instructions have not come.
Lordship, my last representation is of May, lordship.
Maybe.
Yes, I have submitted, but they have not replied. Then suddenly,
Therefore, we'll wait for the instructions.
lordship, suddenly on 15/6, page 58, lordship, page number 58.
Third, counsel for parties, the respondents will obtain required instructions in the matter
Lordship, they may file affidavit, lordship.
and file necessary affidavit.
Yes, lordship.
Pray for interim to be reconsidered on the dates on 15th of July. Will be reconsidered.
Lordship, they now, lordship, starts the EFC, lordship. Then they will not issue me give me that promotion to assume the charge. I am just my humble submission is lordship.
Your promotion was issued prior to that,
Prior to
the GFC.
yes, prior to the GFC. Then after 2 months of my promotion. After 2 months of
We can't help it without the instructions. What
Yes.
can be done?
my that humble submission, lordship, because he used to salute his juniors, the seniors. He is getting
Those things are
humiliation.
irrelevant, Mr.
Everything is lordship, and his family condition is also not good, lordship.
What is the aspect of family condition?
Because lordship, he under harassment, under this because this is
No.
due to personal vendetta, lordship. This is
Whatever it may be, we are not inclined to pass on half-baked
Lordship,
instructions.
my humble submission is that only that
You
it may be
renew
made-
your
it
prayer
may-
after the
it may be made
retirement.
after, let's say, subject to the outcome of the GFC order. If it is GFC is against me or if the petition is against me, I may be departed, lordship. I may be demoted, lordship. That is different.
No, but where is the vigilance clearance? According
That
to
is
the
as
respondent, it is not there.
But lordship, at page 25, I believe is mentioned, lordship, and it is in record.
Yes, what do you say?
Lord, my lord, in my instruction in page number 2, my lord, their instruction, my lord. Last paragraph, madam. Further, had this office email message when dated 25/5/2020, a request was also made to the 39 Battalion and SHQ through the headquarter NEFTR ITBP to furnish all the disciplinary cases of the aforesaid subordinate officers so as to enable this office to issue the vigilance clearance and certificate and further action regarding the implementation of his promotion. However, requisite information and documents sought from the concerned office was received on 23/6/2026.
It will not be proper, Mr.
Yes.
Govinda.
But lordship, what they will say about page 25? What is it is
I
not my
don't know. They have to say something, but they
Yes, they have not.
they have not said anything.
So prima facie, lordship, therefore I am praying, lordship, before lordship, that at least lordship till the outcome of the petition.
No, no. If the vigilance clearance, what you say
Yes.
is sufficient to give you the promotion,
Yes, lordship.
we don't mind giving you an order. But the question is that in the face of the submission that some vigilance clearance is awaited.
But lordship, my now question would be,
after verifying all the documents, all the records, and they have categorically stated that all contemplated against above the and integrity is beyond doubt. This is their language. That is not my language. This is their certificate. After verifying all these things, they have issued me the promotion order. Now, Lordship, subsequently, maybe there may be something.
We are trying to understand what
Yes.
kept you
Yes.
from May. You have approached
April-
this
April.
court on 22nd of June.
No, they
What were you doing?
as because they had issued me on the 15/6 only page 58. Only on 15/6 they are contemplating. They are saying after 15/6, after within 7 days I have approached.
No, 15/6 is a different issue. Your
Yes.
promotion order was issued when?
On 13/4.
Then
I have approached the authorities. You tell me why you are not giving. They have not
that's
replied.
okay, but
They have not
you
replied.
waited for 2
Suddenly
months.
they have come up, Lordship, with the 15/6 letter. Therefore, I have rushed to the court, Lordship, Honorable Court.
In the absence of instructions, we will not be able to help you.
I can understand, but Lordship, if
You understand that
it can be made, Lordship, subject to the outcome,
we can't do it like that. Let there be papers be proper.
Then
What is the point in giving a half-baked order that be subject to outcome without knowing whether the vigilance clearance is available or further vigilance
Lordship, I
clearance
am
is there?
submitting on the basis of the record.
You are
They are
submitting,
not
but
able to
the
issue. They are
CTC
they are
has
not
not been able to furnish the instructions. Get it by Friday.
Yes.
This Friday.
Yes.
Yes.
Yes, Lordship.
Friday.
Obliged.
Released on Friday,
Lordship.
enabling learned CTC to obtain clear instructions whether the writ petitioners for a giving effect to the writ petitioners promotion order dated
13/4/2026.
13/4/2026, whether any further vigilance clearance, etc., is necessary. In the face of the vigilance clearance already issued,
Yes.
dated
Page 25. Dated, Lordship, 24/6/2020.
24/6/25, which is enclosed as an HSC to the writ petition.
Yes.
Let these instructions be placed before the court.
Lordship. Right.
Item 61.
Yes.
May I please, Lordship? Lordship, I had filed an additional certificate on 22nd May 2026, and that is on record. That was in response to an office circular. Now, the basic foundation of transferring the petition in contravention to the company's own guidelines has been exigencies of service. That has been the basic foundation. I will draw your attention, Lordship, now. Para 11 of page
You are entitled to be in a place for how many years?
5 years, Lordship.
5 years. When do you complete your 5 years?
Lordship, I have completed 2 years in January.
2 years.
Only 2 years.
Now they have shown some exigencies.
Exigencies of service.
Right.
Which is a contradiction, and I'll state why. Lordship, your attention is drawn to para 11 of page 81. This exigency of service which they are talking about is that 2 of their employees are retiring or their contracts are set to expire in April 2026.
Mr. Dotto, you revisit the grievances, pass an effective order on whatever claim she has raised. Redress her grievances as per the procedure prescribed.
That can be done.
And we close it. Yes. Heard Mr. D. S. Bhattacharya, appearing with the petition, Mr. S. Dotto, the counsel assisted by Mr. The respondents. The petitioner before this court is employee. Petitioner was at the relevant point in time, the petitioner was posted at
Namsa.
Namsa in the state of Arunachal Pradesh. Personal issues, she applied for leave. While she was on leave, the petitioner was informed that she has been transferred from Namsai to Rishikesh in Uttarakhand by the impugned transfer order dated 2nd January 2026. So, being agreed, the present writ petition has been filed. The learned counsel for the petitioner submits that this transfer order is in violation of the transfer guidelines issued by the company. Where is the guideline not available?
Not sure because. Please 31.
As per clause 6 in the guideline, it is provided that the normal tenure of posting will be 5 years for executive and supervisors. And generally, employees will be considered for transfer only after they have spent a minimum period of 5 years in one location. So, the counsel for the petitioner submits that she was posted in Namsai in
On 22nd of January 2024.
22nd January 2024. Therefore, as per clause 6, a tenure would ordinarily expire only in the year 2029. And in terms of the guidelines itself, she is not to be considered for transfer without having spent the minimum period of 5 years. Submitted that without giving any grounds and reasons. While the petitioner was on leave, the transfer has been issued and petitioner being agreed, therefore is approached to court. By virtue of by the court by issuing notice, the transfer order suspended or stayed, and the same is still subsisting. Then the counsel for the petition submits that the ground for issuance of a transfer in violation of the conditions prescribed under clause 6 of the transfer and posting guideline is the ground of exigencies of service, which according to the petitioner are not supported by the facts which are pleaded in the writ petition. Mr. Dr. Senior Counsel on the other hand strongly objects to the submissions made, submitted that these transfer guidelines are framed by the company and which do not give any enforceable right to any employee. So, guidelines specifically provide that transfer can be resorted to in exigencies of service. Submitted that because of resignation of some employee, same rank or position of the petitioner, she was required to be transferred presently to her new place of posting, and in addition to the petitioner, other persons have also been transferred. So, the learned counsel submits that the law laid down by the FX court in respect of the fair and judicial review of transfer orders very clear that ordinarily the courts will not interfere with transfer orders unless they are mala fide and arbitrary in nature. So, having heard the learned counsel for the parties, that while the transfer guidelines categorically lay down the procedure and the manner of transfer, and also that the department is within its rights to transfer any person ordinarily and specifically because of exigencies of service. But the fact remains, the writ petitioner was on being on personal ground. And certain allegations are leveled against some of the officers, the department, of causing undue harassment to the petitioner, while rendering of services. Therefore, the case of malice is sought to be protected by the writ petition. Considering the issues and the facts which are pleaded before the court, this court is of the considered view that the respondents, being a public sector undertaking, being conscious of the hardships and difficulties of its employees, of justice if the petitioner is permitted to ventilate the grievances in detail before the respondent authority by filing a fresh representation. And the event of the writ petitioner doing so, the respondent authority will sympathetically and consider the submissions and the representations made, submissions and the grounds urged in the representation, and thereafter pass appropriate orders. So, while disposing of the representation, the authority, the respondent authority will also take into consideration the fact that the petitioner is a lady employee, therefore considerations necessary and due in respect of such lady employee are taken into account before the order is passed by the appropriate authority. So the petitioner will file the representation within 2 weeks from today, enclosing a certified copy of this order before
Just
respondent 3. 4.
just one. I think general manager,
Number 4.
number 4.
Respondent number 4. Petitioner is permitted to file her representation to email if so required. At the official email, if so required, the respondent authority will thereafter consider the matter in its entirety, including the guidelines of the transfer and posting policy, thereafter pass the reason and the speaking order. Needless to say, for any orders that is passed, copies thereof shall be served on the petitioner. So before such an order is passed, the petitioner may be given a right of personal hearing if she so desires. The writ petition accordingly stands disposed of. The interim order passed earlier continue till the matter is disposed of by the respondent authority or till give us a date 31st July or any date earlier.
But within
weeks they will file the representation.
Right.
Thereafter, my lord, within 1 week, we can complete all the work.
All right, 31st July or till the date of
Yes,
the
The
disposal of the
order is passed.
order is passed, whichever is earlier. Date petition accordingly stands through disposed. Okay,
The two persons.
so you raise all these issues before the authority by filing a necessary application. giving all
Comprehensive
details.
representation can be filed, so then everything can be.
Sorry?
Comprehensive